Imagine you have lived in Australia for 20 years. Your home is here. Your job is here. Your children may have been born here. You are an Australian permanent resident, and the word permanent seems fairly clear. Then you plan an overseas trip and discover that returning in that status may require a fresh visa application. Until 30 June 2026, the standard charge was $490. From 1 July, it became $1,475. The number changed almost overnight, but the rule underneath it has been confusing people for years. This fee does not hit every permanent resident every time they travel. It matters when the travel facility attached to a person's permanent visa has expired or will not cover their return to Australia and they need a resident return visa. If your travel facility is still valid, this is not your bill. If you are staying in Australia and not traveling, you generally do not need this visa either. But for the people who do need it, the standard application fee has risen by $985. 2 standard applications in one household now total $2,950. That is not a small annual adjustment. It is a rise of just over 201%. So how can somebody be a permanent resident and still need permission to return? Because Australian permanent residency contains 2 separate ideas that sound like one. A permanent visa allows you to remain in Australia indefinitely, but your ability to leave and re-enter as a permanent resident depends on a travel facility, which is usually time-limited. Home Affairs states it plainly. Permanent does not mean automatic re-entry. For many people, the original travel facility lasts 5 years. When that period ends, their right to live in Australia has not simply evaporated while they remain here. The problem appears at the border after overseas travel. To return as a permanent resident, they may need a valid resident return visa, known as subclass 155 or 157. The old travel facility cannot simply be extended. A person applies for another visa, and the new travel period depends on the rules and their circumstances at that time. That means 2 long-term permanent residents can face the same charge, but receive very different periods for future travel. This is where the system gets more uneven. If you have spent at least 2 of the previous 5 years in Australia as a permanent resident or citizen, a subclass 155 can generally carry a 5-year travel facility. If you do not meet that residence test but can show substantial ties that benefit Australia, the travel facility may be up to 12 months. In narrower circumstances involving compelling and compassionate reasons, a subclass 157 may provide 3 months. The eligibility details matter, and this is general information, not a prediction of anyone's visa outcome. But look at the fee structure. 1 application fee, 3 very different outcomes. A person who receives 5 years pays the same base charge as somebody whose circumstances result in 12 months or even 3 months. The government charges for assessing the application, not by the length ultimately granted. That distinction is legally tidy. From the household budget, it can feel anything but tidy. There is one important exception in the new rules. An eligible applicant holding a valid passport from a listed Pacific country or Timor-Leste pays a lower base charge of $505. For other applicants, the base charge is $1,475. So Australia now has 2 prices for the same visa class, depending on the applicant's passport and eligibility for that regional concession. Now to the obvious question. Why did the standard price almost exactly triple? The government's case is straightforward. The explanatory statement says visa application charges support cost recovery, the financial sustainability of the migration system, demand management, and system integrity. It says specific increases, including the return residence visa class, are intended to better reflect the purpose and use of particular visas, their administrative costs, and demand patterns. That is the official rationale. It should not be replaced with a conspiracy theory. But it can still be tested against the numbers. The same 2026 regulation applied a broad 25% increase to many other visa charges. The resident return charge did not rise by 25%. It rose from $490 to $1,475. The public explanatory material gives categories of justification. but it does not publish a calculation showing why assessing this application now requires exactly $985 more from a standard applicant. The previous year's change makes the contrast even sharper. From July 2025, the charge moved from $475 to $490, an increase of about 3%. 1 year later came the 201% jump. This was not routine indexation wearing a larger coat. It was a deliberate visa-specific setting. That missing bridge matters. If the increase reflects administrative cost, what part of the process became 3 times as expensive? If it is also demand management, what behaviour is the higher charge supposed to change? Permanent residents are not choosing whether to begin a new migration journey. Many are deciding whether they can visit a sick parent, attend a wedding, take children overseas, or keep connections with the country where they were born without risking their ability to return in their existing status. The government's human rights assessment calls the higher charge moderate in the broader context of international travel and says it does not impose a substantial or unreasonable burden. That is the government's assessment. A couple facing $2,950 before airfares, or a person offered only a short travel facility, may reasonably judge the burden differently. Citizenship may remove the need for a resident return visa, and Home Affairs itself suggests eligible permanent residents consider it. For some people, that is a sensible long-term path. But it is not a universal escape hatch. Citizenship has its own eligibility process, and some countries restrict or do not recognise dual nationality. A person may face legal, family, inheritance, or identity consequences in their birth country if they naturalise elsewhere. Saying, "just become a citizen," can turn a complicated life decision into a checkout suggestion. So who really benefits? The immediate beneficiary is not mysterious. The Commonwealth receives an extra $985 for each standard application charged at the new rate. That revenue may support administration or wider government priorities, but revenue is still the first measurable transfer. The system collects more money per application, while the applicant receives no guaranteed longer travel period in exchange. The regional concession also shows that government can shape this fee around a policy goal when it chooses. Eligible Pacific and Timor-Leste passport holders are protected from most of the increase. Everyone else is placed on the $1,475 setting. That does not make the concession wrong. It raises a useful design question. If the price can vary by regional policy, why can it not also vary with the duration granted, the applicant's circumstances, or the actual complexity of the assessment? There is another quiet effect. A steep, recurring charge makes citizenship look financially attractive for those who are eligible and comfortable taking it. That may not be the stated intention, and it should not be described as one. It is simply an incentive created by the numbers. One standard citizenship application may be cheaper than one resident return application, although citizenship, passports, and personal legal consequences make that an incomplete comparison. For viewers, the most useful step is also the least dramatic. Check your travel facility in Vivo before you book or leave Australia. Do not assume the expiry date on an old document describes your current position. If the facility will not cover your return, read the current Home Affairs rules before applying. If your residence history, former status, or substantial ties make the answer unclear, immigration assistance should come from a registered migration agent, an Australian legal practitioner, or another person authorised under the rules. And do not let a viral headline convince you that every permanent resident now owes $1,475. That would be false. The pressure falls on the group whose travel facility has run out and who want to cross the border and return in permanent resident status. It is a narrower group, but the people inside it can have very little practical bargaining power. Our view is that a bespoke 201% increase deserves a bespoke public explanation. Publish the calculation behind the extra $985. Show the administrative cost. Explain the demand management goal and report how many applicants receive 5 years, 12 months, or 3 months. Then consider a lower fee for shorter facilities, a cap for families applying together, or a hardship pathway for urgent, compassionate travel. Those options would not make border rules optional. They would make the charge easier to connect to the service and the outcome. Permanent residency sounds like the end of the visa story. For many people living in Australia, it is. But the moment they leave, a second clock becomes visible. The status may be permanent, the travel facility is not. So should an existing permanent resident pay the same $1,475 whether the result is 5 years, 12 months, or 3 months? Or should the fee follow the outcome? Tell me what you think, and tell me which everyday Australian system we should follow next.